All right. So, hi, everyone. I'm Paul Grand. I'm the CEO here at MedTech Innovator. I am happy to welcome all of you, whether you're part of our cohort here on Zoom, or whether you're on YouTube or LinkedIn, anywhere else. If you're watching this live stream, either live or recorded, welcome. This is part of the MedTech Innovator APAC Live webinar series that we do throughout our APAC Accelerator. You can find out more about that at medtechinnovator.org/APAC Live. You can also go to medtechinnovator.org/live if you want to see the US program schedule. We have 2 separate webinars. There's also biotoolsinnovator.org, and you can learn about our life science tools program as well. So MedTech Innovator, for those of you who've never been here before, is an accelerator, but we're a downstream accelerator. We focus on companies that are not at the idea stage, that are way past that. We're looking for people who have technology already developed. It may still be in the development process, but they're well along the way. In many cases, they've got technology that's already being used in patients, in some cases even being sold. So that's the stage, which means we're going to tackle things that tend to be a little more, let's just say, more than just the 101. But one of the things that we like to do is to dive deep into certain areas. And tonight we're going to be talking about intellectual property. And intellectual property is really very different depending on whether you're in biotech or medtech or digital. It's different. It's not always the same. And the strategies may be different. It may be different from region to region, or even deciding where to follow your IP. There's all sorts of things to talk about. So we're not going to get through everything tonight, but we're going to cover a lot. And specifically, we're going to cover topics that are interesting to our cohort. So we talked to our companies in advance and asked them for some of the things that they were interested in covering. And we're going to cover some of those topics today as well. What I want to introduce now, is introduce our guest for tonight, Hin Off from Wilson Sonsini Goodrich and Rosati, who I'm happy to say MedTech Innovator has been a partner of Wilson Sonsini for many, many years. We've had the pleasure of doing our competitions. The very first competition we ever did was at Wilson Sonsini's annual medical device meeting. And we've continued that tradition and been doing it now for 10 years. So happy to have you here, Hin, and I'd love to hear you tell us a little bit about yourself and what you do at Wilson Sonsini.
Thanks, Paul, for the introduction. Hello, everyone. Greetings from Palo Alto, California. So I'm a patent attorney at Wilson Sonsini. So as some of you may know, we are a Silicon Valley-based global law firm that provides legal services to startup companies, growth enterprises in both the technology as well as the life sciences area. So I've been practicing patent law, intellectual property for about 10 years, with the past 7 years at Wilson Sonsini. So our clients range from digital health, medtech, med devices, software, biotech, clean energy, I would say across the entire gamut of technologies. So we work with companies of various sizes. So I'm just thrilled to be here with everyone tonight. Looking forward to it.
Very good. And as you said, Wilson Sonsini works with companies at all stages and all different areas. I know that for years, one of the things that I've loved about Wilson Sonsini is that you take on clients in many cases at the earliest of stages, when people just have an idea, and the general attitude at the firm has been, we want to make sure these companies protect their technology and develop with the right strategy. And in many cases, Wilson Sonsini has done that work without charging initially and kind of deferring fees and allowing the companies to then, kind of get some key things in place. And once they raise their capital, to either go ahead and take fees or sometimes take equity, and both, changing the fees over to equity as well as even making investments directly from the firm. So I've seen all sorts of great things in that respect in terms of really being a huge player in catalyzing this early stage healthcare ecosystem. So thank you guys for that. We really appreciate it. So what I wanted to do is kind of cover a couple things up front. One of the things that I know is kind of let's just get it out of the way up front, is what are the different categories of IP? It's not just patents. There's other things too. So what are the key categories of intellectual property?
Sure, Paul. So intellectual property, IP, so it's considered as like an asset. Yeah. So the four main categories of IP are patents, trademarks, trade secrets, and copyrights. Yeah. So the cost benefit of each type or each IP asset can vary. So for example, patents would provide the greatest exclusivity in terms of blocking competitors and also securing your company's competitive advantage in the marketplace. So trademarks have their own purpose in terms of protecting the goodwill of the mark itself. As for trade secrets, this is information that is important to the company, but the company wishes to keep it confidential. So essentially not disclosing it to the public and not revealing the information in a patent filing. So copyrights, they protect works of authorship, not ideas. Yeah. So the key distinction between copyrights and patents is that patents protect innovations, the ideas, the concepts, whereas copyrights protect like the work of ownership. So for example, if you have a software code, there are two ways of protecting it. You could file for a patent that kind of covers what the algorithm is trying to do, what the code is doing, or you could copyright the code per se. Yeah, but patents will provide greater protection, because by filing for patents, you're claiming what the algorithm can be configured or what it's intended to do, as opposed to a very specific type of code. I hope that provides a good high-level overview.
It's a great overview. It's a great overview. And I know a lot of people tend to focus on patents, but some of these other things you said, copyright, trademarks, these are all important and are at times overlooked. And we talk to companies who, we say, oh, your name is whatever. If you trademark that, oh, not yet, but we're planning to get around to it. These are things they should be thinking of from the beginning, because it does become important down the road. So that's good. And also, with respect to patents, it also gives you some exclusivity, right? Some period of time where you can exclude competitors from, for at least a period of time. Is that period of time different? I mean, we're going to be talking today, about different markets, about the U.S., about various Asia Pacific markets. Is the term different from market to market of exclusivity, or is it pretty harmonized?
It's pretty harmonized. Yeah, it's roughly about 20 years from the earliest filing date. Yeah. So this patent term. So one thing about patents is that it's territorial. A U.S. patent would only cover U.S., whereas a Chinese patent would only cover U.S. And likewise for European patents, it's essentially a bundle of rights that would be validated in different countries within Europe, including UK. Yeah. So think of patent rights as territorial, and that extends for about 20 years, roughly.
Okay, great. And generally speaking, what's patentable? Or maybe the opposite, what's not patentable?
So I would say that the products that you're developing, most of the innovation is patentable. So software itself, algorithms, if they're integrated into a practical application, which I'm sure all of the audience companies would be doing. Yeah. So this alone would make it patentable. Yeah. So in terms of what else to patent, we could be patenting the architecture, the software architecture itself. What's happening on the back end? What's happening on the front end? How do users interface or interact with your tool itself? What's the workflow? What are some of the data processing steps that are unique to it? If you're using machine learning models, what kind of models are you using? How are you training the models? How are you validating those models? If you're commercializing a medical device, the device itself would be patentable. The methods of use itself would also be patentable. and also the methods of manufacturing the device itself, of making the device. So these are the various types. Essentially, it can cover systems, methods, apparatus, devices. So there are lots of different categories. And so these different types of device classes of things to patent would inform how we draft the claims. For example, if we are trying to have method claims, which are usually a series of steps, operations, versus a system claims, as in what components or modules are in the system itself. So as for what's not patentable, so laws of nature wouldn't be patentable. So if we are trying to say patent E equals mc squared or Maxwell's equations, or something that is grounded in, say, in basic physics, or if it's a natural phenomenon, so that wouldn't be patentable. So likewise, naturally occurring things. So for example, genes. Genes itself isn't patentable. So one thing about patentability is that different jurisdictions, countries have different standards regarding patentability. So for example, in the US, there's a series of case law that went up to the Supreme Court. So gene panels are not patentable per se, but the use of the gene panels for various purposes, target users, applications, those might be potentially patentable. Outside of the US, gene panels can be patentable. So if you're thinking of an international patent protection or a strategy, and if you're thinking of having patent protection worldwide in various jurisdictions, so consider as in which kinds of subject matter is patentable in which countries and which isn't. So usually there will be some ways that we can, I would say, get around some of those restrictions by drafting the claims in a certain manner or the patent application in a certain manner. And there are also ways to harmonize like a patent application that would serve well in multiple jurisdictions, say in China, in US, and Europe as well.
What about the concept of obviousness? I know that's a big part of this too, right? So how inventive is something? If it's obvious, then can it not be patented?
That's right. Yep. So to answer that question, perhaps I should mention about the 4 basic criteria for patentability in the US. So the first is a type of subject matter, which we discussed earlier. So as in laws of nature, natural phenomenon, those are not patentable. But if we have an apparatus, methods, systems, devices, those are patentable. So that is a basic criteria, the first. So it has to be of the right type of subject matter. The second criteria is that the invention itself needs to be novel. So it needs to be new. It needs to be unique. So by that, there shouldn't be any prior art reference. So what can be a prior art reference? Prior art reference can be another patent that was filed previously. Prior art can also be a publication or a technical paper, a PhD thesis as well that's published. So anything that is in the public domain will constitute as prior art. And if there is a single piece of prior art reference that discloses everything that we're trying to claim, then the invention isn't novel. So that's the second most important criteria for patentability. The third criteria is obviousness. So usually for obviousness, the examiners or the patent examiners are not able to find a single reference that discloses everything that we're trying to claim. But the examiner is able to find certain combinations of prior art references that the examiner says, if we piece together or combine those prior art references together, we'll arrive at your invention. So obviousness rejections are extremely common in patent applications, as in most examiners will typically rely on a combination of prior art to reject the claims. And because obviousness is something that is usually in retrospect and also hindsight, so to the extent that we are able to show to the examiner or explain to the examiner why why your invention isn't obvious in view of those modifications. So essentially, that's where most of the back and forth with the patent office is, where the fight is. So trying to show to the examiner why our invention is non-obvious in view of those prior art references. And the fourth criteria is that the patent application, it has to contain a well-written disclosure, so that describes the invention in detail. So the patent application cannot be too thin, as in it cannot. So if you are trying to claim an electric car, we won't be able to just have like one page that describes the components at a very high level. So we'll have to describe the invention in detail, as in so how the invention works, with description, with drawings, and the scopes, and the claims would also have to be clear. So for a patent application, the claims will define the scope of protection of this piece of IP. So think of the claims, that could be 10 claims or 20 claims. So this set of claims will define the scope of protection. So think of it as a circle. So this circle will define the estate, the property estate. And in order for the scope to be well defined, the claim has to be clear on its face. So this, in summary, these are the 4 basic criteria for patentability in the US.
That's really helpful.
Applicable for most countries as well.
Yeah, I was just going to ask that. Okay, so applicable for most countries. That's good.
That's right.
And what about business methods? I know for a while that was popular here, but business methods are not, they're not patentable now, right? At least in the US.
At a high level, business methods, no, but if we are able to integrate it into a practical application, potentially, yes. So if we think about maybe, like say, if we are trying to patent a ledgering system, so ledgering systems has been known in accounting for a very, very long time. But if you're trying to patent something that utilizes blockchain, so like some kind of a decentralized technology, so potentially that might move the invention into the realm of something that is a practical application. So much of it depends on how we frame it, draft the claims. So if we draft the claims as 2 business methods, like 2 commercial, like with finances and things like that involved, it could be difficult to get those claims allowed. But if we frame the invention, say from the perspective of what are some of the technical advantages, improvements, and the contributions that this invention can make, then that could help to make some of those business method-like inventions to be more likely to be patentable.
Okay, and you already mentioned software a little bit, and you mentioned machine learning a little bit too in some of the components there. I just want to go back to that for 1 second, because I know a lot of our companies and a lot of companies that we encounter in general at MedTech Innovator have AI now involved in an important way in their algorithm, and but AI is. It's not the kind of algorithm that you can necessarily just write up. Here's all the components of our algorithm. Now it's something the computer has arrived at on its own in some ways. So again, I just want to just be clear on what parts for a company that's using AI, let's say for like image analysis, and they're gonna identify lesions, let's say in an image. What's patentable there? Is it in terms of the AI algorithm? What are the pieces that they can protect?
The things that can be protected is not just the models per se, the algorithms, but how the algorithms are processing the data and how the output is being used, how the models are being trained. So especially for AI machine learning patent applications, examiners can sometimes find those to be very abstract, in a sense that AI sometimes, if we think about a deep learning, sometimes examiners will see those as a black box. So any detail that we could help to shed more light into how the black box works, what's going on, what exactly is the algorithm doing, how are we training the models, how are we building or developing those models, what kind of training data do we use, what do we do to validate the models, and what is the output of the model basically, and how the output is being used in some real world application that can help to inform perhaps diagnosis or perhaps triaging, so perhaps patient intervention as well in real time. So those combination of aspects would make this type of this kind of cases patentable usually.
Great. Thank you for clarifying that, because it's always confusing to me.
No problem.
All right, so let's cover a different area. So as we've said, companies are in some cases going to commercialize. Many are going to commercialize in just one market, and that's where it's going to stop. Because they're not going to be successful, or they are going to be successful. Maybe somebody will acquire them, and then they'll be the company itself that started maybe isn't actually commercializing anymore. It's now the acquirer. But those intellectual property rights in other markets can become very valuable. So one of the questions that that always comes up is where should a company file its intellectual property? How do you determine where to file? And what are some of the advantages of filing in places maybe where you have no intent to commercialize, or at least not in any immediate term?
That's a great question, Paul. So the question as to where to commercialize, it really depends very much on the company's commercialization plans, where the company's partners are located, who are the customers, where is the product being made, being manufactured, where are the distribution channels, and also where are the investors located? So do the investors want to see the company having patent protection in certain markets? So usually when we think about, say, the top markets, so the US, Europe, China, possibly India as well, Japan, Korea. So this would be the usual countries that come to mind. And even if some of these places are countries that the company has no plans to commercialize in the near future, but sometimes just falling in those jurisdictions can help to secure at least some kind of a provisional patent protection. So in case the company's plans change, it pivots, or the IP assets get licensed to, say, another company that is doing business in that region. So basically that could be value to, I guess, filing in some of the more common top jurisdictions. But having said that, patent filing is very expensive in multiple countries. So it really depends on the budget. So what budget does a company have in terms of just filing patents in those various jurisdictions and pursuing patents? So the good news is that for the patent process in each country, it normally takes on the average 2 to 4 years, sometimes even 5 years. So there are ways, there are buttons that we could push, we could use to delay costs. So some of our clients, they may fall into a certain market jurisdiction, but their intent is to speed up the examination process, say in US and Europe first. So to secure some fundamental patents in those key jurisdictions, while delaying costs in some other jurisdictions. So that is one way of, I guess, controlling the patent spend across various countries. And oftentimes, once a company receives its first, say, issued US patent or issued European patent, so that issued patent can be used as a leverage to speed up the examination process in other countries as well, say in Singapore. Because the Singapore Patent Office may refer to the findings that the US or the European examiners have already conducted, and use that to inform the patentability of the invention in Singapore. So I would encourage that the companies work closely with the IP Council in terms of budgeting and also strategizing which places to file and when to file.
So that's you just touched on another subject that I think comes up a lot too, which is if you're filing in multiple markets, do I need local counsel in all those different markets? And if I do, who's the quarterback? Who's gonna find these people for me and manage them?
So there will always be local counsels that are managing the local filings because the patent law in each country is different. So only attorneys or patent agents that are licensed to practice in that country would be allowed to do, say, conduct certain processes with the patent offices in those countries. But having said that, what Wilson Sonsini and our firm and also other firms have done is that most likely the company would have an IP counsel that serves as a quarterback. Yeah. So basically, you would have a law firm that would help you to define what is your IP strategy, what is your filing strategy, when do you file, what do you file on, and where do you file. And the quarterback IP counsel will help to manage all of the other local counsels, in terms of making sure that things get filed and also making sure that the IP strategy is harmonized across different jurisdictions, different countries. So having a good quarterback is important in terms of just thinking about how to structure the patent filings and the IP portfolio.
I mean, I know you're biased, we'll see. But if a company, let's say, was in Korea, for example, or a company was in Japan, but they say, hey, my major market is going to be China, or my major market is going to be the US. Do you think that whatever the primary market is should be where they have their quarterback, or should it just be the whatever their local? It should be if they're in Korea, it should be their local Korean firm. If it's in Japan, the Japanese. Where do you recommend?
I feel that the quarterback is actually agnostic of the geography. Yeah. So I think a good quarterback IP counsel will be able to function universally across different countries, different regions. So this would be an IP counsel law firm that has the company's interests at the top of the mind, in terms of what can they do to help position, put the company in the best position, like say for the next financing, or if the company is looking to be acquired, or if the company is looking to go public. So the IP quarterback counsel would probably have perhaps like a 5-year vision plan in terms of, okay, this is day one that we're working with the company. In 5 years' time, where does the company see itself, and what can we do to help the company achieve its goals? So for Wilson Sonsini, we've worked with companies that are based in China, in Korea, Singapore, Israel, many countries in APAC. But what we do is usually we look to see what is the company's IP needs. So which markets are the top on their consideration list? Where do they want to file for patent protection? And based on that, so our law firm, we have an office in Beijing and also in Hong Kong. So on the China side, we can advise on those aspects here. So if the company is very interested in, say, like the Japanese market or the Korean market, so we have partners and also local counsels in those regions that can help to advise on some of the intricacies of, say, Japanese patent law or Korean patent law. But most of the time, the way we see IP is that it's not merely about, say, securing a patent per se, but rather we let the business strategy drive the IP strategy. So the business strategy should lead and the IP strategy should follow, as opposed to the other way around. So we want the IP to be able to map to the business strategy, so that when investors ask what is the company's IP strategy, we'll usually prepare a set of slides that shows exactly what are the key IP buckets or key IP assets that the company has, and how it maps to the company's technology and product roadmap.
That's really helpful to think about it from, as you said, let the business lead. And in that respect, I know something that you and I've talked about previously is following where your competitors are. Not just where you're commercializing and you're saying, okay, we're going to roll out here, but also, your competitors. Why is that important?
So that's important because, say, if you haven't filed for patent protection in a region where you know that your competitors, known competitors, actual competitors, or potential competitors are operating, then your competitors could potentially try to duplicate what you're doing, or they might try to reverse engineer your product. And if there is no patent protection in that market, it's essentially up for grabs. So up for grabs. So by filing for a patent protection in those regions that your competitors are interested in or operating, so you create this zone of exclusion that helps your company to block the competitors from operating in the space.
That's very important. So and I think a lot of companies don't necessarily think that way, which is really, so I'm glad you're sharing that. You mentioned investors a bunch of times. And I know that is, it's going to be different depending on, the sector, perhaps. Mm-hmm. But you get involved, on the IP side in investor due diligence, all the time. So maybe could you talk a little bit about, where IP comes into the investor due diligence process, and is that different in biotech and medtech and digital health, or is it pretty much the same in every sector?
That's a great question. So for investor due diligence, it depends on typically which stage of the financing round, whether it's a Series A, B, C, or later stage, and also the size of the round, and also the technology sector, as you had mentioned. So for biotech, IP due diligence tends to be very stringent, as in investors would want comfort, reassurance that the company has freedom to operate. So if you're producing, like, say, some drug or therapeutics, so investors would want to make sure that those are covered by patent filings. So by the company's own patents. And investors will also be concerned or interested to know whether there is any freedom to operate issue. So that's in the biotech space. So in the tech space, here I'm talking about pure tech, say software. So investors will still conduct IP due diligences, but the scope of those IP due diligence may vary. So some investors may ask about freedom to operate, some investors may not. And some investors may ask if the company has any patent filings, and some might be okay with just the technology being kept as trade secrets at the present moment. So it really depends on the type of investors and the comfort level, the zone. So in terms of digital health, I would say that it's probably veers more on the tech side. As for medtech, I would say that it's a combination of both. Investors probably will want to see some form of a due diligence for freedom to operate studies, but those might not be as extensive, as thorough as, say, biotech companies. So for example, like a high-level FTO search analysis might be sufficient, whereas for biotech companies, investors might want a scorched earth freedom to operate analysis and assessment. So I would say that's basically the three different types of categories here, and the levels of due diligences involved with the financing round. So obviously, as the size of the financing round gets higher, gets larger, the stakes are bigger. So investors would typically then tend to want to do a deeper dive by investigating, by knowing what IP does the company have, and are there any freedom to operate issues. So these are the two basic fundamental questions that almost all investors, VCs will ask.
Yeah, I remember I used to be a VC, and I remember that I had different experiences at the firm I worked at. We were very focused on IP. It was very
Mm,
important. In fact, they had every one of us as part of our training. We had to take the patent bar review
mm,
course so that we at least understood the fundamentals of patents and their construction and things like comprising and all that. Anyways, but the point is, like, that was very important to us. And I always
mm,
found it interesting because I talked to some other investors who would say
mm,
something like, hey, as long as there's freedom to operate, we don't care about patentability. We just want to make sure
mm,
that you have a license to hunt, and things like that.
mm,
And it was just interesting because, like, some firms have very different opinions
mm,
about what's important in
mm,
IP, but there's no question that it's important to everybody
mm,
because eventually, when you get to the end, at least for an investor, which is some type of an exit,
mm,
uh, depending on if that's to an acquirer,
mm.
the acquirer is often making a
Mm.
build or buy decision that comes down to your IP.
That's right.
Maybe your customer base too a bit, or
Mm,
some other things, but ultimately that IP is a huge part of it. So it's, at least for us, it was always a key focus. So we've covered the investor a bit, but I want to cover some other areas. So you mentioned also before that it's expensive to file IP,
mm,
and I'd like to get into that a little more. Because you talked a little bit about budget, and so I guess the question is. I see companies sometimes show up and they'll say, we
mm,
filed 27 patents, and I go,
mm,
27 patents?
mm,
That
mm.
sounds very expensive. Is it quantity or is it quality? What's important?
It's always quality. Yeah. So it's much better to have one or two broad blocking patents, as opposed to multiple, very specific, very narrow patents. And the reason is that if you have a few blocking patents, you could use those blocking patents to potentially deter your competitors from operating in the space. So essentially, your blocking patents become a freedom to operate issue for your competitors. On the other hand, if say you have 10 to 20 very specific, very narrow patents, so those might look good on paper in terms of the quantity. But if we dive into the scope of the claims and we find that the claims are too narrow, it's easy to work around, then the value of those patents is almost questionable, because say in a due diligence, the investors' IP counsels will ask about the scope of the claims. And if the claims are too specific, too narrow, and could be easily designed or work around, then that patent is given very little, I would say, patentable weight. Yeah. Yeah. So I would say always focus on quality patents. And sometimes what we do is that we can generate a very detailed, thorough patent application that could be 50 pages, 100 pages long with lots of schematics, drawings, and we could have multiple claim sets. Say we could have 50 to perhaps 100 claims. So all of these claims are covering various aspects of what you deem to be the competitive advantages or the features that you're trying to protect. Yeah. So this is what we will call an omnibus patent application, or an omnibus filing. So from this one single filing, we'll be able to harvest, we'll be able to mine multiple patents out of this one single patent application. And it's also cost less because we only need to enter this omnibus application, like say, we just have to file it into Europe, China, US once. And once the first filing has been made, we can use this, what we call the parent case, to spin off multiple continuations or divisional applications. So one way to think of it is, think of this omnibus patent application as a trunk of a tree. So from the trunk of a tree, you can spin off multiple branches. So each branch could be a different country, could be a first patent in a different country. And from that first patent, you could continue to harvest additional sub branches. or additional patents. Yeah, so kind of the idea if we were to visualize is to try to make this kind of an oak tree, make it as wide, as broad-reaching as possible. So perhaps this is why the name patent tree came about, or family tree.
Yeah.
You
know, you talked about narrow claims, you know, not being, I've seen that all the time where somebody makes really, really, really narrow claims and you know, it's so specific that, you know, it really doesn't provide a lot of protection because somebody can just, you know, do something a little bit different, you know, and still able to operate. But on the flip side, I mean, can something be too broad in your claims, or is there no such thing as claims being too broad? Is that?
That's a great question, Paul. So there's always I would say the eternal debate as in the breadth of the claims. Yeah, can a claim be too broad? Yeah. So I think a claim might be too broad if we know for sure there is prior art that would invalidate that patent claim. Yeah. So if we know for sure there is this prior art reference or combination of or certain prior art references that clearly invalidate this broad patent claim, then the broad patent probably isn't that useful. Yeah, because say if we were to try to assert it against a competitor, they would use the prior art to try to invalidate the patent claim. Yeah, and this patent would fall. Yeah. But on the other hand, if we have a broad claim, that kind of veers in a gray zone. It's broad. There's no single prior art reference that discloses every element of the claim, but aspects of it are still being mentioned or taught in the prior art. Yeah. So I think for broad patents, that's exactly the gray zone that we're trying to strive in, whereby the breadth of the claims, the scope of the claims is up for debate. So this is where the true battle lies. Say if the patent ever gets asserted in litigation. Yeah. So patent litigators will be trying to construe what are the boundaries, the scope of those claims based on the language. Yeah. So claim drafting is I would say, a very important exercise. I think there's a fine line, a fine balance, as in making something too broad and making something too specific. And just finding that right balance takes a bit of time to master.
No, for sure. That's where we have you to do. And you know, I discourage, like everything, I always discourage people from trying to. I found companies like, oh, we write our own patents. You know, I certainly encourage them to have experienced counsel helping them with that, even if they do a lot of the drafting themselves. You know, and some of the initial drafting, you know, I think, you know, the strategy that you bring, I think is, you know, obviously like anything, you want to have an expert in trying to do it yourself.
Right. So actually, Paul, if I may add a brief comment about the scope of the patent claims. Yeah. So when we submit claims or examination, so think of the scope of the claims as a circle. If we try to make the circle as big as possible, so for patent examiners, they will look for prior art to try to reduce the size of the circle. So based on our back and forth with the patent examiner and the patent office, the eventual goal is to try to reach kind of a middle ground. Yeah. So think of this as possible like Venn diagrams. Yeah. So a circle in the middle. So if we start with claims that might be too narrow at the beginning, so the size of the circle can only shrink, during the examination process.
That makes a lot of sense. It's a good way to visualize it. I want to go back for 1 second to some of those other jurisdictions for a moment, or some of the possible places to file. Okay. You mentioned India and China. And so one of the questions I have is, you know, about IP enforceability in those regions, you know, and just respect for IP. I remember it wasn't too long ago that people would, you know, the common thing was, oh, China doesn't respect intellectual property. They just copy everything. But I know that's not the case anymore, right? I mean, does China respect IP now?
So I would say that so IP in China has grown a lot since the very early days. Yeah. So China these days, it's one of the most prolific patent filing nations in the world. Yeah. So I think it's probably on par with the US, or it might even have overtaken the US in terms of just the sheer number of patent filings, both within the country. Yeah. So if China is encouraging patent filings, Chinese patent filings, yeah, so it would mean that they are giving recognition to patents. So we've also seen cases whereby Chinese patents have been asserted, litigated. Yeah. So in terms of enforcements, this is becoming, I would say, so it is trending towards a positive, I would say, in terms of just recognition and understanding the value of IP rights. So it's a very different world from perhaps, say, 20 or 30 years ago, in terms of the treatment of IP.
And what about India?
As for India, I think it's catching up, it's following. So in terms of, say, the robustness of the IP system, it might not be where China is currently at, but I would imagine that being such a populous nation, yeah, and a strong and a very important commercial market, the value of IP, the importance of IP, the recognition will only tend to increase. Yeah. So usually, I guess for many of the countries, recognition of IP and the establishment of the IP system, it takes time. Yeah, and it involves partnership with other countries, with other patent offices around the world. Yeah. So I guess over time, as the countries collaborate more with the US patent offices, the European patent offices, Japanese, Korean, yeah. So essentially, I would say that this would trend towards some kind of harmonized system. You know, so the goal being to be respectful of IP rights.
Good to hear. All right, so I can't believe we only have like 13 minutes left in the first hour here in the public portion. I want to switch gears and talk about, you know, we've been covering kind of what to do. I want to flip that around and cover the mistakes. What are the things not to do? You've had the benefit of, you know, of a long career, and I know you've seen a lot of mistakes along the way. So let's talk about some of those. What are some of the common pitfalls that you see, you know, maybe any company, but especially early companies make? Let's talk about some of those. So I'd love to hear your thoughts.
I would say that one of the most common pitfalls is just rushing to tell the world what our innovations are and to disclose it. Yeah. And also to speak with third parties such as customers, investors, contractors, and such. Yeah. So anytime that we talk to a third party, even if it's covered under an NDA or a CDA, there's no guarantee that those contractual obligations would always be, I guess, met. Yeah. So we would recommend that companies, they file patents on what they think is important prior to speaking with any third party. Yeah, basically. So just having some kind of a two-pronged protection, the patent filing. So with an application serial number and a filing date. Yeah. And making sure that the patent filing does protect the disclosures. So basically getting something on file before we talk with third parties, and also always insisting to have a CDA or NDA in place with the other party that they are talking to. Yeah. So this would help to safeguard the company's interests. Yeah.
And even with investors, I mean, I know a lot of investors say they won't sign CDAs.
Yes.
Do you think is that, you know, and people need the money, so they, you know, a lot of times say, okay, that's fine. We'll still you. Do you think that's a problem though? You know, in terms of CDA, I mean, should companies by default still ask for a CDA before disclosing anything that's you know, that's not been protected by IP?
I think it really depends on the depth of the discussions with the investors, also the stage. Yeah. So are the parties at a very initial stage where they are just contemplating the possibility of an investment or a business opportunity? If it is, then potentially there might be some high-level slides. Like say, if there are certain slides or marketing materials or like a executive summary or one page pitch deck or pitch that the company could share with investors. That probably should be fine. That should be fine. But if we start talking about, like, say, going into technical discussions, product roadmaps and stuff, like a more in-depth discussion, but prior to formal due diligence. So that's when I guess companies do really have to weigh as in what are the forms of protection that they need with this particular party, right? So I guess just so it's something that law firms, because we are not usually directly involved, so it's difficult to tell if, say, those are just merely high-level business level discussions, or is there really some keen interest in, say, moving forward with a deal? So if there is a term sheet, that's great. So with the term sheet, sometimes we might be able to skip the CDA, but it really depends on the company's comfort level. So we would suggest always ask to have an NDA, CDA in place, and also for their own protection, just to make sure that they have their own patent filings in place. And if investors want to talk about freedom to operate, so that's when we need to request for a common interest agreement. Because when we talk about freedom to operate, we're talking about third-party patents, and this is very sensitive, highly privileged information that we are going to share with investors regarding what is the company's non-infringement positions, the risk level of those patents. So it's best to have those protected by what we call a common interest agreement, a CIA. And a CIA is different from an NDA or from an NDA. So those are the different types of agreements and the types of protection that they would recommend.
Common interest agreement you should try and get in place before you're talking to investors in depth, or
regarding freedom to operate, regarding third party,
specifically the FTO. Okay,
that's right. It's very it's fairly unique. Fairly specific to FTO. That's right.
Good. Thank you for clarifying that. What about websites? Companies get excited and they're like, "Oh, we've got this great, this great technology," and they publish, some stuff on their website about our technology before they filed maybe some of the IP. Is that problematic?
That can be problematic depending on how much was disclosed on the website. So the good news is that the US has a 1-year grace period for anything that is disclosed publicly or offered for sale. So if the company had published on their website certain like a white paper or some details about their technology, so the company can still file for a US patent without that website becoming prior art against their own patent filing data. But this grace period doesn't apply outside of the US. So if we are talking about the rest of the world, like Europe, China, Japan, India, so once the website is made public, once it's live, that website alone and the disclosures within, it will become prior art against anything that we file on later. So that's not always fatal, because we can always write a patent application that contains a lot more, say, improvements, a lot more delta, things that won't disclose on the website itself. And we can pursue claims on those aspects that haven't been disclosed.
We're a pitch competition as part of what we do, right? Where the companies are out presenting in various ways during the tech interview. What about doing that? You're at a conference, you want to put up some slides and show some things about your technology, maybe some of your data or some of the specific things. Again, is that considered public disclosure if it was at a conference?
It's considered public disclosure, unfortunately.
You got to protect everything before you don't show anything. Okay. That's important. What about some other common pitfalls? How about competition, competitive landscapes? Let's talk a little bit about that. How is that important?
So it's always good to know what is a competitive landscape. So whether the competitors have any patents, patent filings, which jurisdictions those patents are issued. So those would provide a good indicia of whether you should be filing for patents and how many patents you should be filing for. So if your competitors are filing aggressively across the world, so there might be something that a question that we should ask: are we too late to the game? Yeah, and also what kind of space can we carve out? Yeah. So on the other hand, if the competitors haven't done much patent filings, or we haven't seen any relevant patent filings in the space that they are operating in, so essentially this means that there's a lot of white space for grab. So this is what we call white space analysis. So think of it as a crystal ball, what you're working on. If this innovation is extremely new, novel, and others in the industry or in other sectors haven't really caught on to exactly the nuances or the innovations that they are working on, now is the best time, the perfect time to lay the stakes in the ground by filing for your own patents. Because once you file for your own patents, you'll be able to exclude others from trying to copy what you're doing. Once like this sector becomes very hot, yeah, or there's a lot of financing investments going on. Yeah. So at the same time, your patent filings, once they publish, they'll become prior art against any future patent filings that your competitors might make.
Yeah,
so just being a competitive landscape is good. Yeah.
You mentioned trade secrets earlier a little bit. So what about training employees? Because I know that it's one thing to have maybe the key inventors who are working on the device or the software, and meet with them and talk about IP. But what about everybody else? Like how do you train your staff properly to to protect trade secrets and all sorts of things?
So it's probably best to have an IP council, perhaps give like a training session to the employees, both existing employees and also like for new onboard hires, as in what are the practices regarding the keeping of information confidential. So one thing about trade secrets is that, say, if a company says that all of our ideas, innovations are kept as trade secrets, that's good in a sense that they haven't disclosed it to the world. But then having trade secrets doesn't prevent others, your competitors, from say reverse engineering what you have done, and also trying to independently come up with what you've already done. So trade secrets, in a way, it's like a silo, but it doesn't really provide any exclusionary advantage. And sometimes investors, they might want to see a company having at least 1 or 2 patent filings, as opposed to keeping everything as trade secrets, because patents, is a form of a very tangible asset. But for trade secrets, the company has to take reasonable steps to always maintain those trade secrets within the company and to make sure that those information is kept confidential and isn't leaked. And sometimes it can be hard with employees, especially startup companies. Employees can move around very quickly. So even though there are employment agreements, confidentiality clauses, but those might not always be bulletproof. So it's probably better to have some form of patent protection in combination with trade secrets, of course. So like specific codes, algorithms, training data sets. So those might potentially be things that are kept as trade secrets within the company. Proprietary training data.
Yeah, okay, that's great. All right, well, look, we've covered a ton of stuff already, and there's so much more that we could get into, or so much deeper on a lot of these issues. So, I really appreciate your time, Hin, to go through all this with us. So thank you. And for our cohort that's here, they're going to get a chance to ask you some questions directly in the Q&A. But for, maybe for everybody else out there, if people want to find you, and follow up on with you, how do they find you? Is it LinkedIn, or what's the best way for people to find you?
I would say LinkedIn. Also, my profile is on the Wilson Sonsini website. So if you do a search on Google for Hin Au, Wilson Sonsini, or WSGR, you'll be able to find. Yeah. So I'll be happy
Perfect.
to chat with anyone if they have any questions regarding IP strategy in general.
Terrific. And I know you're on the West Coast of California like I am, but you're a native of Singapore originally, right? So
That's right. Correct. Yep.
so you do so you know your roots are in Asia Pacific.
Yes.
And you get back every once in a while as well.
I'm sorry.
I said, do you get back to Singapore every once in a while as well?
Oh yes, I do. I try to go back every once every year, but since the pandemic, I haven't been back that often. But I'll try to go back more often. Yeah. So my family, extended family, is still there.
Yeah, well, I definitely encourage you when you're there next, look up my team in Singapore. We'd love to meet up and talk to you more in person. That would be great.
Certainly. Yeah. So if I may share a fun fact, so my family is actually in the restaurant business. It's called Fatty's Restaurant. So for some of, I guess, the folks in Singapore, you might be familiar with the restaurant. It's almost like an institution. It's been around for many, many years. Fatty's Restaurant.
Fatty's Restaurant. Where is it?
It's in Burlington Square. Yeah.
Burlington Square. Okay. Well, I'm going to be there. I'm leaving tomorrow night for Singapore, so I'm going to go look it up.
Great. Awesome.
I'll drop your name. So I know you. All right, great. Well, thank you for the fun fact, and thank you for all the time today. And as I said, I encourage anyone who's out there who's interested in learning more to reach out to him and his great firm, because Wilson Sonsini really has done a lot of terrific work for this industry. So thank you very much for that.
Thank you, Paul, for the great discussions.
All right, so stick around. Don't go anywhere, Hin. And same thing for our cohort. Of course, we're going to get into some Q&A in a minute. But for those of you on YouTube or LinkedIn or wherever else you might be watching this video, thank you for tuning in. MedTech Innovators webinar series, as I mentioned, is weekly. And you can find all of the episodes that we've already covered at medtechinnovator.org/APAC live. I encourage you to go there anyways and get the schedule for what else is coming up. Next week in Singapore, we're going to have the finals for our Asia Pacific program, and we'll have that also on YouTube. So if you're interested in learning more about the companies that are part of MedTech Innovator, that's where you'll be able to find it, either on our website or on our YouTube channel, either one. So again, thank you for tuning in. We're going to end our live stream now, and